Okay, Sajjad sir, please start.
Very good evening. I'm happy to welcome you all at the 9th and the last session of the UMSAILS-UAP International Virtual Conference on the impact of COVID-19 pandemic in the legal field. I'm MD Sajjad Hussain, Lecturer of Law, University of Asia Pacific. We have two distinguished panelists with us today, Dr. Shahidin Malik, Advocate, Supreme Court of Bangladesh, and Professor Dr. MD Mahabubur Rahman, Faculty of Law, University of Dhaka. In this session, we have three papers presented by the participants. First paper will be presented by Nikhil Dongle and Sadia Anjumanara Tripti on access to information as a human rights and the pandemic. Mr. Nikhil is from Kathmandu School of Law, Nepal, and Ms. Sadia is from Department of Law and Human Rights, University of Asia Pacific. The second paper will be presented by Dr. Habil Christina Nezel on a few reflections about the importance of the cyber security of financial services during the COVID-19 pandemic. Dr. Habil is from Faculty of Law and Administration, Sanchin University, Poland. Last paper will be presented by the Priya Aasan Chaudhary on how is the Digital Security Act curbing the free speech and other fundamental rights during the pandemic. Ms. Priya is from City University of London, United Kingdom. This whole session will be moderated by MD Abdur Rahim, Assistant Professor, Department of Law and Human Rights, University of Asia Pacific. Now I'm requesting Mr. Abdur Rahim to take over the session. And thank you, everyone. Thank you all.
Thanks, Sajjad, for your nice introduction. We are at the last session of 3 days international conference on the COVID-19 pandemic and its impact in the legal field in general. Distinguished panelists, dear participant, my dear student, and faculty members, welcome to this session. Assalamu alaikum. We are privileged to have two distinguished panelists, Dr. Shahidin Malik sir, a distinguished jurist in Bangladesh, and Dr. Mahabubur Rahman sir, Professor, Faculty of Law, University of Dhaka. From the 8th session, last 8 sessions, it is evident to us that change is integral part of our life. Life will be changing. And we have to cope with the new situation, new phenomenon. It is very natural. So at present, we are living in a technological world, technology-based world. So our legal field must be also reshaped, remodeled in compliance with this technology. Otherwise, it would not be adaptable with the new situation. The law academics, law practitioner, the judges, the legislature, they may not be able to adjust with the new situation. That is why such kind of international conference or national conference, research or seminar, symposium are to be held to reshape our legal field, to understand the impact on it, because we know the coronavirus is not the last pandemic. There may be future situation where our life may be again stopped if we are with the actual life, if we are not adjusted with the digital life. That is why it is compulsory for us to rethink about the legislation, about our procedure, practice. Hence, I think that this kind of conference will be helpful for the lawmakers, policymakers, and we will be able to send them some suggestions for adoption with the new situation. Without further word, now I'd like to request the presenter to present their papers. Before that, you know the format of the conference. The presenter will be given 15 minutes each. And after presentation of all 3 papers, the panelists will be requested to give their valuable feedback to the panelists.
Sorry to interrupt.
Sorry, sir?
20 minutes, sir. So 20 minutes.
20 minutes. Or presenter, sorry, I'm sorry. Presenter will be given 20 minutes. And the panelists also will be given 20 minutes for discussion on all 3 papers. So the panelists will be discussing at the end of the presentation of all papers, and then question answering session. Okay, at the very beginning, I would like to request Nikhil Dangal, a student of Master of Law, Kathmandu School of Law, Nepal. His paper is Access to Information as a Human Rights Amid the Pandemic. Please, Nikhil Dangal, start your presentation. You may also share your slide.
Thank you, sir. So with due regards, if I would ask, if I'm audible?
Yes, you are.
Yes.
Well, thank you, sir. Good afternoon, everyone. Respected panel of judges, professors, teachers, students, colleagues, and everyone present here. This is Nikhil Dangal, along with my team member, Saidat Tipti, and we are going to present a presentation on the access to information as a human right amid this pandemic. Okay. Our paper ID is 2118.
Okay, bas.
I'm requesting everyone to mute their microphone, please. Thank you.
With due respect, if there's any technical mistakes, we beg your pardon. So with the permission of the panelists, I will like to present the paper. So these are 2 statements that we resembles our paper to some extent. So first one is Robert Weiner, is a father of, considers as a father of cybernetics, like to leave effectively is to leave information. This statement signifies some sort of importance of information in this present world. And second one, I have taken an interesting statement from the Guardian columnist, which says that the use of propaganda is ancient, but never before has there been the technology to effectively disseminate it. So this statement somehow resembles our paper. And with this, I would like to move on to the presentation. So as we all know, information is very important in this 21st century. It has been ushered by the modern mass media. So the modes of knowledge distribution have been changed due to the usher of this modern mass media, including the print media, hard copy, electronic, soft copy, and the most importantly, social medias as well. The transmitting the knowledge at a much faster rate through the social media, and even without going through infiltration. So with this, without infiltration, there is a situation that there's a spread of various types of information today. So there comes a concept called information disorder. So it's also called infodemics. WHO defines infodemics as the overabundance of information, may be accurate or not, that makes it hard for people to find trustworthy sources and reliable guidance when they needed it. So according to Council of Europe report, there's 3 types of things are involved in this infodemic. The first, misinformation, disinformation, and malinformation. The first 2, misinformation and disinformation, are somewhat similar as they represent the same false information, but the intention are different. Misinformation is created to deceive others, while the disinformation is created to harm a person or any organization in itself. On the other hand, malinformation is a situation is based on reality, is used to inflict harms on people or an organization. At these circumstances, if you are to say why this situation arises, to this Guy Berger, and director of the Freedom of Expression and Media Development at UNESCO, has said that the motives behind this disinformation could be many things like political aims, self-promotion, or attracting attention, maybe as a business model as well. So they play on emotions, ignorance, prejudice, fears, and claim to find some certainty and meanings to a reality. As this situation, COVID-19 situation, brings in uncertain things and abnormal situation arises, this misinformation sometimes gives uncertainty and meaning to this abnormal situation. So people are more attracted to this. Having said this, our paper has the objective to analyze the right to freedom of speech with the fundamental right to access to information of South Asian countries, and also explore to attempts made by the South Asian nations in dealing with the same. So as regard to the methodology, it is a purely and doctrinal research with a quantitative and qualitative approach. The data includes the primary and secondary data. The data are then studied and analyzed to draw up the findings of the research. And this research is a purely descriptive and exploratory research. So with this, I would like to introduce the topic that when the COVID-19 pandemic began, the significance of Article 12 of the ICCPR came into light. It states that the right of everyone to the enjoyment of the highest attainable standard of health, and the health includes both the physical and mental. And most particularly, the Article 12(2)(c) of the ICCPR signifies that the state has the right of the citizens to prevention, treatment, control of the epidemic and endemic of or occupational diseases. So at this time, the whole sort of civil and political duties rights are curtailed to maintain this ICCPR economic social rights. So we can see a more sort of relevancy in this twin covenants amid this pandemic. So similarly, international health regulation has also has obliged states to fulfill their human rights obligation in responding to the international spread of diseases. So at this, following the WHO statement that COVID-19 may never disappear completely, so it is our understanding that we need to mitigate or live with the situation. That is, the technology could help in it. So we believe that technology can help in first three aspects. First, the technology could help in the preparedness of this outbreak of infectious disease. It helps to learn, predict, and anticipate the future diseases. Like, for an instance, let me take an example of it took almost around health authorities for 4 months to identify the existence of the SARS virus. But at this time, the Canadian company called Blue Dot took only a couple of hours to detect the outbreak of COVID-19 because of the technology called the big data analysis. Similarly, at number 2, it helps to mitigate the virus. The technology helps to mitigate the virus effects upon the citizens' quality of life. So it is most particularly important to look at the role 11 of the SDG, where it has focused on to make cities more sustainable and safe. So let me take an example of the contract tracing used by the South Asian government, South Korean government. The technology called the City Data Hub was launched to contract test the individual. So each infected persons could be traced so that the liberty of all the peoples could not be limited. So the people could be contract and mitigate the virus without limiting the liberty rights of other peoples. And along the line, there is an technology could help in the awareness or information exchange to the public. So since this virus is a kind of new virus that have been developed, so technology could be one of the important tools to disseminate information about the nature of the virus and ways to preserve it, like through right to information. So there are certain caveats, like when the technology is used, it should be used in the least intrusive manner without violating the right to freedom of speech, right to privacy, as well as human rights standards. So along the line, there comes the importance of right to information. So a right to information as a part and parcel of right to speech and freedom of speech. It was first accepted in Resolution 59 of the United Nations General Assembly, and alone it is accepted as in Article 19 of the UDHR and ICCPR to receive and information, and also South Asian have guaranteed in their respective constitution. Also, the ICCPR commentary of the Manwar Novak was believed that this right to freedom of speech extends to all sort of medium, including various types of social media as well. So it is considered as a cornerstone of democracy, but with reasonable restriction. The reason that why I'm focusing on right to speech along with the RTI is that there's a jurisprudence developed by Indian Supreme Court that there's a right to as well as a right to be educated, informed, and entertained. So as we see about the right of the citizen, there's another duties of the government to ensure that people have the right. So in this aspect, there's a right to information as a part and parcel of the freedom of speech, and it is a fundamental right guaranteed by the South Asian Constitution, as well as various RTI individual acts. So focusing on right to information, one of the pro component is proactive disclosure. Proactive disclosure, in this aspect, the author believes that the right of the individual to get the trustful information proactively from their government bodies. So in this aspect, the proactive disclosure, let me introduce you the proactive disclosure. So proactive disclosure is a disclosure of the information regarding the COVID-19 updates or activities that the government is conducting to mitigate the virus as well. Why? Because it leads to the transparency, accountability, as well as to guarantee the fundamental rights of the people. And when it's like individual RTA Act has determined the periodic updates of the maybe website or information, maybe annually, quarterly, monthly, and how through the web indicators that like Nepal have developed 20 indicators to proactively disclose to its citizens, and where is the public announcement or website, and who means public and private bodies. So with regards to this, there are many hurdles to proactively disclose information. First one is sanction. There is no sanction in the sense that when they breach the proactive disclosure scheme, that they haven't, when they do not disclose them, there's no some sort of sanction in the individual RTA Act, and also the implementation mechanism like the Information Commission do not have sufficient power to punish them, as well as there's no political will because of they might, if they support this proactive disclosure, it might be detrimental to the political party itself. And third thing that is hurdle is the awareness of the people. So people are not aware that they could get the information. It is their right to get proactively the information about the government. So at this aspect, let me highlight the situation of South Asia. It's more of a number game, but I would like to deal some of the reality that it may signify some of the reality of South Asia. Like for an example, South Asia includes the 24% of world population. This vast majority of population with a single click or clickbait of information, the vast majority of people get that maybe incorrect information. So internet penetration is almost as 51%, and also it is believed that rural population and teenagers sometimes believe that they are more vulnerable to this inaccurate misinformation. So 66% of rural population are present in South Asia. The literacy rate is 72%, which is somewhat taken averagely good, but compared to other regions is comparatively low. So World Press Freedom Index also can be an indicator in this context of misinformation. So South Asia holds an average of 33.6% score, and which is almost at 103rd in 180 countries. So this is the situation of South Asia. This might not indicate the real situation, but there's some sort of, it might indicate, it might signify the situation or something like that. And mechanism, the South Asian countries have taken some of the mechanism to cope up with this situation. Like Afghanistan have converted the ultra poor program, TUR program, to raise awareness, to dispel myth about this pandemic. Indian government adding 8 local languages as distributing the reliable information with the help of WHO and through the app called MyGov. Nepal, along with the help of UNICEF and WHO, is running the Mythbusters, and the Press Council of Nepal has also closed the 25 unregistered website which has alleged to have spread the disinformation. And Pakistan has used the National Command and Operations Center to deal with this myth and disseminate real news. And Maldives, the use of the Health Protection Agency is used in multiple languages to transfer information through social media platforms like Twitter and Facebook. Sri Lanka has opened like fact checkers such as Watchdog Sri Lanka, and also developed a national guideline with the help of health ministers, health promotion bureau, and epidemiology units. And Bangladesh have opened an anti-misinformation campaign called the Osho Chini, which literally means that let's know the truth, and also running different platforms, information hubs like National Corona Portal, different apps like Corona Tracker BD. So these are some of the mechanisms that helps to mitigate the situation of infodemics. But I wouldn't say it is inadequate, but I would prefer to say that it would be more effective if we could effectively implement the RTA regime. So to conclude my presentation, as we all know, information has a very important role in the 21st century. It's a key role in semblance of power among the countries in a fragmented and divided world. And
conclude within few minutes.
Oh,
within 3 or 4 minutes.
Sure, sir. So the spread of propaganda was very prevalent at that time in Cold War to attract towards the two alliances. And it's now it's 21st century, this information is what keeps the system smooth functioning. So technology could be one good aspect in South Asia to mitigate this misinformation. And at this time, media literacy could be one of the important aspects. And there are 3 stakeholders in RTA, like the demand seekers, that is the people who seek the information, and holders, which holds the information, like the government bodies, and promoters and facilitators like WHO and Information Commission. So 3 concerned stakeholders of RTA can contribute to smooth functioning of state structure and develop the better system so that it would be a better place to live. With this, I would like to conclude my presentation. It was an honor. We are very thankful and honored to have shared our presentation at this conference. If the panel does have any question, we'll be happy to deal it at the end part of the program. Thank you very much.
Thank you, Nikhil, for your nice presentation. Yes, human rights is the first, and other thing like business, development, transport, this will later, but human rights is the first. Especially for your slides. It was well prepared, but unfortunately, if I am not wrong, while you are showing the SARC slide, the flag of Bangladesh was not properly presented, if I am not wrong. Saida Anjumanara, Tripti, are you here?
Yes, sir, I'm here. Yes, sir, I'm here.
Have you noticed it?
Sir, pardon, but in our laptop or our slide, this is showing the flag. In detail, there is red color.
Bangladesh flag, there will be green and there will be red circle, but we have given a white circle. However,
no, sir, in our slide, it is showing the exact color. I have
red circle.
Yes, sir. Yes, sir. We give it, sir. Yes, sir.
I might be wrong.
Technical issue, sir. Pardon.
Okay. Don't worry. The slides are well prepared. Thank you. Then I'll request the next presenter. She's a professor, Dr. Habil Christina Nijol. She's a professor of Shenzhen University, Poland. Her paper is a few reflection about the importance of cyber security of financial services during COVID-19 pandemic. Very, very time of the topic, which is also relevant in Bangladesh, like your Poland. Please start your presentation, madam.
Good afternoon. Thank you for the possibility of present my presentation and paper. I will share my screen.
Please.
I hope it's seen. Yes, and I.
Not yet, but yes.
From the beginning.
Yes, now it is.
Okay.
You can see it.
Okay. I choose this subject because after the pandemic started, a lot of transactions, also financial transactions, which before were made by cash, was cashless. So also not only the consumers, but also financial institutions had to face two new problems because before the pandemic, of course, there were problems like cybersecurity, cyber crimes, but it was not so up to date and not so urgent like during the pandemic, because almost all people, not only in Poland, were in lockdown, so they had to do shopping online. All the financial transactions were also usually by online bank and so on. So the problem which was interesting for me was how the pandemic influenced the cybersecurity of financial services and also the situation of consumers, because for example, since a few months in Poland we have a problem because some frauds are calling to clients of banks. I had also one of that call, and they are trying to receive some personal data. They know, for example, when I had this call, the person who called me know my name, and what was the most difficult and what was new in comparison to before that kind of frauds was that the number of the mobile phone was the same like the number of the bank. So they use some computer program which can show the number of the bank, but in fact there's the call from the fraud. So there's a big problem in Poland now, that a lot of people who received this call, they gave their personal data to the people who just steal their money from bank accounts. So for me, it was the first case when I met that kind of practice. So I was interested how this cybersecurity during the COVID pandemic is developing or not. There is more frauds, or how the institutions are preparing for this new situation, also for them, especially financial institutions, and how the consumers behave, how they feel about they feel that for example, banking transactions or financial transactions, they are saving if they using the mobile banking, for example, or not. So I prepared the schedule also of my paper, that shortly about the cybersecurity definition, financial services, because there are some specific kind of services, cyber threats, and the problems and challenges during this COVID pandemic connected with this financial services and its cybersecurity. The main idea and the main aim of the paper was how the COVID pandemic affected the cybersecurity of this financial services, and it saw how the financial institutions adapting to the new situation, because of course this was also the new situation not only for the consumers, for all the entities, also for governments and also for institutions, among others also financial institutions. Of course, the COVID pandemic caused a lot of challenges. One of them is connected with the cybersecurity, because most of the changes of lives of remote working was connected with the lockdown and the requirements of social distancing. Of course, we have a few waves of the pandemic. I think that the most difficult in Poland was the first wave, when people had to adapt to the completely new situation. Also, not only paying online or using the mobile banking, but also to stay at home and work and using remote working and similar situations. In consequences of all the situations, of course, the cybersecurity of financial services, especially with mobile, for example, mobile banking, are even more important than it was in the past. Of course, I choose this financial services because they are specific. I will say more sentences about this later. Of course, they're specific because not only with its connection with monetary transactions, but also with the specific requirements of protection of personal data. The consequences of losing this personal data may be very difficult for the consumer and client, because they can lose all the money and savings. So there are very difficult and important of the cybersecurity of this kind of services is highly important. Therefore, the issue connected with the security, especially in financial services, in financial market, is very important. Of course, the financial institutions and its clients, especially consumers, because as you see, the clients of the banking, of the financial institution can be also entrepreneurs. So I concentrated on the consumers because of the consumer protection law. They are highly protected because of their weakness as a part of the transaction on market, especially not only on financial market, but in general on the market. Many of the consequences of pandemic were connected with digitalization of different kinds of services, especially financial, and because of the cashless transactions, which were introduced in a bigger scale than before the pandemic. The people were, even the old people, for example, who never used the cashless payments using credit card, they were forced to do this, especially in the first part of the pandemic in Poland. So the problem of safety of these financial transactions, especially e-financial transactions, and protection against the cyber threats are very important, especially now. Financial institutions also changed the way of the contacting with clients, with consumers. The new channels are more digitalized. Of course, not every financial institutions were good prepared for this process. So the pandemic just showed them that how important is to start preparing to be more digitalized, to also introduce some new protection strategies against or plans against the cyber threats. I think that the pandemic is a very important factor which forced this financial institution to introduce this kind of new solutions concerning the digitalized of their services, especially with especially in contact with clients which are not professionals, such as consumers. I choose one definition of cybersecurity because there are many organizations and, of course, in literature. In these definitions, the cybersecurity is defined as a prevention of damage to, protection of, to, and restoration of computers and other electronic systems, communications, to ensure its availability, integrity, authentication, confidentiality, and non-repudiation. So as we see, the cybersecurity is quite wide issue, because in general, it is connected with all kinds of information which is connected with all kinds of digitalized channels, or transaction or channels, all information. Especially the most important is protection of personal data, but not only. Even on Facebook, if we show too many information about us, we can have problems connected with this, because some can use our profile and create some false profile and send some virus, for example, computer virus, to our friends. So the information is one of the important part of the cybersecurity. The protected information is should be also protected in all kinds of forms, so in all ways of digital communication in cyberspace. Of course, this issue is a subject of regulation in many countries. I choose the European Union law, and which also is introduced and in Poland, which is a member of EU. So the formal framework is connected with this kind of legal regime, the European Union and Polish national regulations, which usually are connected with the European Union part of this law. For example, I also choose one of the definitions from the one European Union regulation, which in which this Cybersecurity Act, in which the cybersecurity means the activities necessary to protect network and information systems to users of such systems are the persons affected by cyber threats. As you can see in this definition, we can see also the new issue connected with cyber threats. So this is also an important part of the cybersecurity, because if we say about cybersecurity, we have to protect the information, the all information systems against something which the most dangerous so-called cyber threats. The second part of my paper is connected with financial services. Just to sum up, the financial services, there are also many definitions. The most general is that there are transactions involving financial instruments, different credits, insurances, and so on, swaps, and it depends on the kind of financial market. Of course, the financial services, there are also many definitions, but if we say about financial services, we have entities of the transactions, which are consumers or client, and the financial institutions. There are also different. For the most popular, I think, there are banks. And the place when the space where the financial services are taken is financial market, which is the part of market in general. Is this one of the kind of the markets. And there are different financial services. I would, the most good example is there are different kind of bank services, because such as credits, payment transaction, credit card transaction, and so on. One of the I think important essence and the important feature of the financial services is the asymmetry of the entities, because consumers, which are non-professional part of the transactions, they don't have enough knowledge about the essence of the kinds, the consequences of financial services, and another part is professional, like banks or other financial institutions, which have a lot of information, a lot of knowledge about the risks, about the all aspects of the financial transaction. Of course, this is the reason why the consumers are largely protected against other threats on the financial market and other dangers which they can meet in practice when they did or use any financial transactions. Cyber threats, this is one of the essence of cybersecurity, on one of the main reason of this process. Of course, the cyber attacks are usually illegal activities. There are, for example, some kind of means of commissions or theft. Especially in financial service sector, these cyber threats are very dangerous, as I said before, and this kind of the financial sector is also sensitive in terms of cyber security, because a lot of operations is made by using internet information systems, internet channels like mobile banking and so on. Of course, I choose the example of Poland because this is the best national regulation I knew. In Poland, we have the recommendation, which is established by the Polish Financial Supervision Authority, which sets standards in the field of the cybersecurity and for financial institutions. It's about 22 recommendations. They are connected with different fields of cybersecurity, for example, strategy and organization of the information technology, environment, development of it, and so on. So in practice, there are a regulation framework which banks or other financial institutions should use if they are going to prepare some strategy, some strategy connected with cybersecurity and other other documents. Of course, this regulatory aspect is very important in cybersecurity. I must stress that this kind of regulation are not easy to prepare, because they are strictly connected with some technical or IT requirements. So, and this kind of knowledge of IT reality is changing very fast. For example, some cyber threats are evolving, so we have to face with a new cyber threat. So this is very fast process.
Dr. Christina, sorry to interrupt you. You have got last 5 minutes to.
Okay, thank you. I will. We have the strategy of the Republic of Poland, in which these challenges are established. What are the problems and challenges during the COVID pandemic connected with the cybersecurity of financial services? First of all, the pandemic shows that the cybersecurity of these services is become more important. Why? Firstly, we are working from home, so all transactions are also working, shopping, or other activities are doing from home. Just they are digitalized. Second, the financial sector is more attacked. more now. The cyber attacks are more often than before the pandemic started. Especially the financial institution is affected by these cyber threats. And the last factor is that we can during the pandemic, a new cyber threats may appear because we are using more often the digitalized services. Of course, this is information from the Great Britain that the attempts of different cyber threats during the first year of pandemic are more often than before. Of course, what the institutions, the financial and the institution and state can take to prevent the cyber threats. There are many different ways. For example, the investments in building public cybersecurity support structures for the financial sector or internet service providers. So we wait that also state will take some actions to strengthen the cybersecurity in the financial sector. Of course, also banks and other financial institutions should invest in that kind of systems which will ensure a high level of transaction protections against the cyber threats. The pandemic also shows that the digital transformation of financial services is accelerated now, and probably it will last also in the future when the pandemic will finish. One of the consequences of pandemic is also the increase of the limit of contactless payments, as I said before. And to sum up the conclusions of my paper, all consequences of the pandemic are different kinds. One of them is connected with the financial services because of the sanitary regime, lockdown, the increase of cashless payments, and so on. And because of the digitalization. So we see that the increase of digitalization of financial services after the pandemic. Cyber attacks on financial institutions are also, and their clients are also more intensive during the pandemic. So probably the situation will be permanent also after the pandemic will finish, or they will come back, or other pandemic. It depends what will be in the future. So the pandemic shows that the problem of cybersecurity of financial services is very important, become more important than in the past. The consequence of the pandemic is also the growing importance of issues which are related to the cybersecurity of financial services, not only for financial security, financial institutions, for consumers, but also for the state, and also in the field of the regulatory which depends on the states and their strategy, for example, against cybersecurity. Thank you for your attention. I invite you to contact with me if you have any questions. I also invite you to maybe start some cooperation. I'm international exchange coordinator, so I invite you. And I will be very happy if I would ask for your questions. Thank you very much.
Thank you, Dr. Christina, for your nice presentation. It is a global issue that how can we manage the financial transaction in such COVID-19 situation where we cannot go out and where we cannot work on the paper, even we cannot give our signature in our check and cannot draw money from the bank. So in such situation, we have to rethink the procedure, how can we manage it? And in Bangladesh, especially the developing countries or the poor countries, they are struggling with because they do not have the infrastructure, enough infrastructure to maintain it. Often we see the digital fraud, digital forgery, although there are laws in Bangladesh, but those who are who will be implementing the laws are not well trained. So there should be discussion, there should be training on this matter. Okay, our last presenter of today's session, and not only this session, but also the 3 days international conference, is Priya Aasan Chaudhary. She is an LLM student in international law, City University of London. Her topic is how is the Digital Security Act. Digital Security Act means Digital Security Act 2018 might be, if I'm not wrong, curbing free speech and other fundamental rights during the pandemic. It is a very debatable issue in Bangladesh. Please, Priya Aasan, start your presentation.
Thank you very much. Let me share this. Am I audible and visible?
Yes, but it is echoing. It echoes.
Is it better now?
You please continue. Carry on.
Sorry.
If we can manage. Please carry on.
So, good afternoon, esteemed panelists, hosts, presenters, and participants. I'm Priya Aasan Chaudhary. I'm a barrister and I'm currently pursuing an LLM in International Business Law at City University of London. My presentation will be on the issue of the Digital Security Act curbing free speech and other fundamental rights in the pandemic. The Digital Security Act, in short DSA, came into force in October 2018, concurrently repealing Section 57 of the Information and Communications Technology Act 2006. Section 57 was repealed following criticisms and public outcry over its misuse, causing a severe clampdown on free speech in Bangladesh. DSA was passed despite criticisms over its vague and imprecise wordings, opening scope for misuse, and the forcing misuse became a reality from the time it came into force, which exacerbated during the COVID-19 pandemic. The law is applicable in Bangladesh and extraterritorially. I will highlight the provisions of the law most critiqued for curbing free speech and the overall effects of the law on freedom of expression and other fundamental rights of citizens guaranteed under the Constitution of Bangladesh and international laws. The Constitution of Bangladesh ensures fundamental rights for all citizens, including right to free speech, among others. And Bangladesh, being a party to the International Covenant on Civil and Political Rights since 2000 and the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, the CAT Convention, since 1998, is also legally bound to uphold the rights enumerated in these treaties. I would now move on to the law itself. So DSA provides 20 offenses, 14 of which are cognizable and non-bailable. All 20 offenses would be deemed non-bailable for reoffenders. Some of the provisions of DSA frequently critiqued for causing crackdown on free speech include sections 21, 25, 28, 29, and 31. Under Section 21, making or instigating any kind of propaganda or campaign against the liberation war of Bangladesh, spirit of the liberation war, father of the nation, national anthem, or national flag, a non-bailable offense. Section 25(1)(a) makes publishing, sending of offensive, false, or fear-inducing data information with the intent to annoy, insult, humiliate, or malign a person an offense. And Section 25(1)(b) makes spreading confusion and affecting the image or reputation of the nation an offense. Under Section 28, hurting religious sentiment is a non-bailable offense. And publishing of defamatory information online is an offense under Section 29 of DSA. Criminal defamation exists under Section 499 of the Penal Code in Bangladesh and is punishable with a maximum of 2 years imprisonment. Section 29 furthers the same colonial law but provides a different sentence for the same offense committed online. Section 31 makes publishing anything online that creates enmity, hatred, or hostility among different classes or communities of the society, destroys communal harmony, creates unrest, and so on, a non-bailable offense. So there is no parameter as to who would be an offender under the law, given the imprecise terms such as annoying, fear-inducing, offensive, spreading confusion, spirit of the war, affecting the image of the nation, hurting religious sentiments, enmity, hatred, and so on. The list just goes on. Focusing on the statistics, over 1,000 cases were filed within the first 2 years since DSA came into force. 732 cases were filed in 2019, and the numbers gradually kept escalating, with most cases having been filed in 2020. So between 1st January 2020 and 25th February 2021, 738 cases have been filed. The question is, who is the law catering to? So reportedly, law enforcing agencies filed 26.28% of the cases in 2020. Another analysis of 197 cases brought under the DSA in 2020 revealed that 80% of the cases were filed by the ruling party members, their affiliates, or the police. I want to now move on to the concerns surrounding DSA, the first being freedom of expression and press in the pandemic. Article 39 of the Constitution and Article 19 of the ICCPR guarantees the right to freedom of expression and speech, subjecting to reasonable restrictions. The ambiguous provisions of DSA raise questions on whether these permitted restrictions and freedom of expression can be invoked as legitimate defenses for validating the law's broadly defined provisions. And it must be noted that at the peak of the pandemic, while thousands of prisoners were being released around the world, including in Bangladesh, alarming numbers of dissenters of the state's response to the COVID-19 crisis were arrested under DSA for allegedly spreading rumors and misinformation online. In between January 2020 and April 2021, 401 individuals have been implicated under DSA cases for their online expression. Most allegations were reportedly of making critical comments, defaming, sharing cartoons, spreading rumors, and propaganda against the state. Arrestees include journalists, students, lecturers, activists, cartoonists, and also folk singers who were jailed for critical comments, caricatures, and folk songs posted online. And I want to highlight that the clampdown on free speech through DSA during the pandemic also affected children and young people. In 2020, a 15-year-old boy was arrested for making a comment about the Prime Minister. In March 2021, another child was arrested for posting a video online, which was allegedly defamatory of the Prime Minister, the Foreign Minister, and the Indian Prime Minister. In the same month, an 18-year-old young boy was arrested for sharing a caricature of the Prime Minister online. Another concern is that of illegality in arrest and disappearances. DSA provides the law enforcers with wide powers, which include the power to search and arrest without warrant if they believe that an individual's online action to be an offense under the law. There is no established standard for the authorities to determine if a person has committed any offense under the law, making the unfettered powers even wider. It is often reported, including in the pandemic, that persons in plain clothes pick up individuals. Those individuals and their families remain oblivious to the reason behind those pickups. The families also remain unaware of the picked up person's whereabouts until a certain period, sometimes a day, sometimes weeks. And the police mostly deny having those persons in their custody when the families inquire. The picked up persons do not get any opportunity to seek legal help during those brief disappearances, and after this episode ends and the individual reappears, they are produced before the court and are mostly shown arrested under a DSA case. In certain cases, the pickup happens after filing of the DSA case. Notably, Shafiqul Islam Kajol, Didarul Bhuiya, and Mushtaq Ahmed were some of the briefly disappeared DSA accused persons during the pandemic. I would be mentioning them throughout this presentation to highlight the various concerns surrounding DSA cases. Bhuiya's family complained of his disappearance, but the police denied having him under their custody. A case under DSA was filed against him once he was found after remaining missing for 2 days. A similar pattern was seen in the case of Kajol, who went missing for 53 days, 1 day after a DSA case was filed against him for sharing an article on Facebook. Now the concern is, are these pickups legal? These pickups and subsequent disappearances have seemingly become a new pattern for DSA accused individuals. It was sparsely seen while Section 57 of the ICTA was in force. Such pickups would not be lawful arrests and rather would amount to abduction under the Penal Code. It is also in clear violation of Article 33(1) of the Constitution if the police fails to reveal the reason behind an arrest. In 2016, the Appellate Division of the Supreme Court of Bangladesh, in the case of Bangladesh versus Blas, laid down responsibilities and guidelines for law enforcers, magistrates, tribunals, courts, and judges on the issue of arrest and detention without warrant. The guidelines require the law enforcers to allow the detainees an opportunity to call their family members or a friend and a lawyer, and also bars them from arresting without wearing uniforms or while outside their duty. The safeguards under the Bangladesh Constitution, international laws, and the Supreme Court guidelines are often reportedly overlooked in most arrests under the DSA. There are no reports till date on updates regarding investigations on these disappearances or illegal pickups. Moving on to the issue of delaying justice and access to justice during the pandemic and beyond. Bail denials and prolonged detentions without a trial or filing of a police report are usual phenomena for DSA detainees. DSA enables investigations to continue if the Cyber Tribunal extends the time limit for a reasonable period beyond the set 105 days. There is no precision on what would constitute reasonable period. To highlight some widely reported cases on prolonged detention during the pandemic, I want to again mention Mushtaq Ahmed, who lost his life in February 2021 while being in jail for almost 10 months and after 6 bail denials. Shafiqul Islam Kajol was also in jail for almost 8 months due to delayed processes and illegalities. Prior to that, he was disappeared for 53 days. It is the same for many arrestees, which include Ahmed Kishore, who was in jail for almost 10 months. Keeping an accused in jail without trial violates their right to speedy trial under Article 35 of the Bangladesh Constitution, as well as Article 9(3) of the ICCPR. Arbitrary bail denials and prolonged detentions also violate their fundamental rights to equality before law, equal protection of law, and life and liberty under Bangladesh Constitution and the ICCPR.
Priya, Aasan, sorry to interrupt you.
Yeah.
As our topic is related with some sub judice matter, so we should be a little bit careful about the choosing word. There are some sub judice matter.
Sure, but I'm only speaking on everything which is there online already, nothing that I know of personally.
Yes, please carry on.
Thank you. So there is also very limited awareness on access to justice. As was the case with Didarul Bhuiya, individuals and their families often remain confused on the first step to take after an arrest, pickup, or disappearance, especially since many are picked up by individuals in plain clothes without any formal revelation of the reason behind such actions. Another issue is that law enforcers often seek to take an accused under DSA for remand. The provisions of the law make it clear that a person would be considered to have committed an offense based on their online activities. So given the nature of the offenses under DSA, it is unclear as to what other information could be sought through taking an accused for remand or how is it justified. It is also often alleged that accused persons are subjected to questioning about issues unconnected to the actual allegations, and in some cases under grueling conditions, beaten and so on. Widely highlighted cases of torture and DSA accused were of Ahmed Kishore and Mushtaq Ahmed. Kishore alleged being tortured after he was picked up and before being produced in court. He also mentioned that Mustaq Ahmed told him that he too was tortured through beatings and electrocution of his genitals after his pickup. The Constitution and the ICCPR both bars compelling an accused to self-incriminate. The Constitution and the CAT Convention gives the right to protection from torture, cruel, inhuman, or degrading punishment or treatment in custody to individuals. The Nirjaton o Hefajate Mrityu Nibaron Ain, which was enacted in 2013 in Bangladesh, made extraction of information through torture in custody illegal. It should be understood that as soon as allegations of torture on an accused is raised, they become a victim. The pattern can be noted from the few torture allegations of DSA accused during the pandemic, which is that the arrestees alleged torture in the period when they were illegally held after their illegal pickup and not during an official remand. This perhaps makes it difficult for the victim to identify the torturers. In March 2021, Kishore Ahmed filed a case under the Nirjatana Hefajate Mrityu Nibaran Ain against unidentified persons responsible for his torture, becoming the first detainee under DSA to have done so. Article 9.5 of the ICCPR ensures enforceable right to compensation for victims of unlawful arrest or detention. DSA barely provides any opportunity to seek reparation or holding the abusers of the law to account. For instance, government-owned computers cannot be forfeited if an offense under DSA is committed through those computers. The law also gives a good faith defense to potential abusers of the law, as it says that if any person causes any damage to another resulting from anything done in good faith under the law, they would not be prosecuted. Since it is not defined what would constitute good faith or how far can this defense be stretched, the law hardly leaves any space for reparation for persons arbitrarily arrested under the law. There are some opportunities to file cases under the penal code for false criminal cases, but the good faith defense is likely to come in the way. The magistrates may direct a complainant to pay a maximum of 1,000 taka compensation under CRPC in case of false accusations, but this is, of course, a very minimal amount given the reported arbitrariness on accused persons under DSA. The law allows non-transparent removal and blocking of contents. The Director General, DG, appointed under DSA may request the BTRC to block, remove any online content they deem a threat to digital security. The law enforcers can request the DG to remove or block any content they consider to hamper the solidarity, financial activities, security, and so on. The BTRC may then immediately block and remove the content after notifying about it to the government. This leaves a broad scope for curbing free speech through silencing dissenters of all kinds. DSA also enables intrusive surveillance, as the government can collect data information from the intermediaries without obtaining any court order through the DG, who may monitor or inspect any critical information structure. Considering all the available reports of crackdown on freedom of expression and other illegalities relating to cases under DSA, it is essential for the various authorities and rights bodies to proactively act for dealing with the concerns. The National Human Rights Commission should actively recommend the government for effective implementation of international human rights treaties and to take measures for ensuring human rights in dealing with the concerns around DSA cases. The law enforcers should strictly follow the Supreme Court guidelines on arrest and detention and promptly investigate any allegation of disappearance, illegality and arrest, and torture. Court should speed up the bail procedures and regularly...
Yeah, you have last 5 minutes. Try to come to conclusion.
Sure. Thank you. So court should speed up the bail procedures and regularly inquire on the legalities of the arrests and detention of accused individuals and direct for prompt investigations on any allegations of torture or disappearance. NGOs working on human rights and journalists should launch meaningful campaigns to create awareness among the wider society about the concerns surrounding DSA. Government should make the list of blocked or removed online contents available for enabling an independent assessment on the legitimacy of such actions and ensure that an independent authority determines which contents to be blocked or removed under DSA. So national and international rights bodies, lawyers, activists, academics, and other actors have repeatedly demanded review and repeal of DSA and release of persons arbitrarily arrested under the law since its enactment, and especially during the pandemic. So the government should consider collaborating with the concerned organizations and individuals for reaching a decision on the future of the law to ensure human rights in the country. In summing up, I want to reiterate that the concerns surrounding DSA are manifold, which include the broadly drafted provisions enabling crackdown on free speech, the unfettered police powers widening the scope for illegalities in arrest and remand, the emerging pattern of disappearance and torture surrounding DSA cases, government's immunity in conducting online surveillance, non-transparent blocking and removing of online contents, restricted opportunities to seek reparation or hold public bodies to account for anything done under the law given the good faith defense. And in the absence of a comprehensive report on the systematic abuse of the law, it is difficult to determine all the concerns surrounding the law in the pandemic. Bangladesh has slid down in RSF's Press Freedom Index ranking from 150 in 2019 to 152 in 2021, which is the lowest among the 7 South Asian countries, including Afghanistan, India, Pakistan, and so on. The High Court in February 2020 issued a rule asking the government to explain why sections 25 and 31 of DSA should not be declared illegal and unconstitutional. Unfortunately, since there has not been a hearing on this matter and the government has not responded to the rule till date. To conclude, I would say that the law and the action surrounding it is not only curbing the right to free speech, but also equality before law, equal protection of law, life and liberty, safeguards against arbitrary arrests and detention, and freedom from torture and ill treatment enshrined under the Bangladesh Constitution, as well as the international treaty bodies, which has seemingly exacerbated during the pandemic. The law can barely be deemed necessary for the purpose of providing any security, considering the available information on its misuse. So the only way forward would be to repeal DSA immediately. Thank you very much for listening.
Thank you, Priya, Aasan, for your nice presentation. You are absolutely right. We are in the digital world, so we have to work digitally, and our live activities will be involved digital media or digital platform. At the same time, it is claimed by the government that to secure the digital life of the common people, such kind of law is necessary, otherwise their life will be insecure. So there is a dilemma in this matter. I hope your paper will contribute in making a decision. Now it is time for listening from the panelists. Sir, first of all, I would like to request, we have 2 panelists, Dr. Mahbubur Rahman sir and Dr. Shahidin Malik sir. First of all, I would request Dr. Muhammad Mahbubur Rahman sir, Professor, Faculty of Law, University of Dhaka, to make comments on the 3 papers. Sir.
So am I audible?
Yes, sir.
Okay. So thank you, Professor Abdul Rahman, for giving me the floor. So dear attendees, a very good afternoon to all of you. First of all, I must say that I really enjoyed all the papers. All of them are very thought-provoking, giving us insights on the crisis of rights during the ongoing pandemic. But I have some few comments about all the papers. So if I first move on to the first paper has highlighted the problem of infodemic from a right to information perspective. The author have argued that the misinformation and disinformation and also malinformation, they are problematizing our fight against COVID and also shrinking the right to scientific or genuine information. And the only policy conclusion that I could draw from this paper is that they have said that greater right to information can mitigate the problem. My first observation is regarding this proposition. I would say that are we taking this proposition? Are are we taking it very for granted? Because the authors have tried to say that proactive disclosure by the public authorities will address the problem of misinformation, disinformation, and malinformation. And authors have also avoided how the government or the state can handle the problem of misinformation during the pandemic. Should the government go for restrictive measure, or should the government go for more positive information? So on this point, the authors probably could take a position. And the focus of the authors were exclusively on South Asia, but it could be better if we could hear a more bit information about the South Asian responses during the pandemic. And they have said about the problems of infodemic, but the question that comes to my mind is, firstly, have all the states around the world faced the problem of infodemic equally, or is this problem acute in some places, acute in some jurisdiction, and not that much acute in other places? So, because many scholars claim that even if there is misinformation, even if there is disinformation online, the best way to fight against this false information is to fight with dissemination of more true and genuine information. But whenever you try to disseminate true and genuine information, one of the very fundamental requirement is that the person who disseminates the information should be credible. And I guess that the South Asian challenge is not only just spreading of misinformation or disinformation. Rather, in most of the countries of the South Asia, the problem is the credibility of the government mechanisms. Because in all the countries we have seen that government authorities during the pandemics have disseminated many information, many scientific information, many genuine information. But the problem is that a good number of people believe the misinformation more than the true information disseminated by the public authorities. So why this problem? The problem lies basically in the credibility crisis of the governments in South Asia. And that credibility crisis has been developed over the years, and that has only been exposed during the pandemic. So if we do not find the nexus between the credibility crisis of the government authority, credibility crisis of the official information, we cannot effectively deal with the problem of misinformation and disinformation. So I would suggest that the authors may consider linking these two issues together. So that is all that I can say about the first paper, and now come to the second paper. In the second paper, Professor Nijal has brought an important issue into discussion. Certainly, this is very important, and the paper has, from my understanding, I find that the main thesis of the paper is that because of the pandemic, the issue of cybersecurity in financial services has become increasingly important. And Professor Nijal has brilliantly shown and established why this is important. But if I try to be a more critic, then I would say that from one perspective, this proposition is hardly questioned or opposed by anyone. This proposition is almost well accepted. So the paper could go beyond this simple proposition, and the focus could be extended even beyond this proposition. And for that purpose, the author could interrogate or examine international legal standards on cybersecurity in financial transactions. And the author could also show whether the existing institutional and policy mechanisms are failing because of the pandemic or not. So if we could get more policy-oriented suggestion from this paper, then I believe that that could be a very good addition to the literature. And regarding the last paper, Priya, Aasan, Chaudhary, she has brilliantly exposed how the digital security act is violating not only international human rights norms, but also the constitutional standards of Bangladesh. So she has focused on all the relevant sections there, and she has shown that many offenses under the DSA are vague and overbroad. There is no doubt about this. She has also shown that there are many offenses which are basically unnecessary from a freedom of expression perspective. And the paper has also shown that the procedural norms set for these offenses are also deeply problematic. So from a purely doctrinal point of view, I do not find anything to disagree to any of the propositions raised by this paper. But I would like to add some points. The author may consider going beyond the doctrinal aspects only, going beyond the doctrinal aspect. So there are some aspects that this paper can also interrogate. Firstly, my first point is that are we disproportionately putting all the blames on the DSA? Because whenever we are saying that there are unnecessary arrests, when we are saying that there are unnecessary remand, there is an allegation of torture, there is the quizzing on irrelevant issues, etc., etc. Is this basically purely a problem of the DSA, or is this the manifestation of the greater problem of our entire criminal justice system? So that should also be interrogated here. And another aspect is that if we put all the blames on the DSA, basically we are sparing the other agencies who are also responsible here. Because whenever we say about so many misuses of the law, what is the role of the judiciary? Are we just ignoring the role of the judiciary here? Because I think from my understanding, putting all the blames on the DSA is sometimes disproportionate. And secondly, I would like to say that DSA should be seen from a more holistic perspective. So only scrutinizing the provisions of law may not be enough. The first thing that we should understand is that DSA is not only about some penal provisions. If the penal provisions were the main objects, then all of this could be well accommodated in the ICT Act of 2006. Then why has the DSA come? Why has the DSA come? That should first be interrogated. So since all the penal provisions could be accommodated in the ICT Act, but nevertheless this new law has come. So certainly we have to understand that the penal provisions are not the main objectives of this law. But quite often we fall into this trap of camouflage, because in many cases we just focus on the penal provisions. Unless we can interrogate what was the main authority under the earlier act and what is the new authority under the new law, and what are the powers and functions of this new authority, and whether these powers and functions are well defined in law, who are the person working behind this new authority. Unless and until we can interrogate these issues, we cannot understand the main objective of this law. And unless and until we fail to understand this main objective, a critical and complete appraisal of the penal provisions would also be faulting. So we have to first go into the main issue, how the power has been shifted from an so-called independent authority to an purely executive authority. So that should also be interrogated. And from another point of view, Priya Aasan has rightly said that there are many provisions like hurting the religious sentiment, like tarnishing the images, etc., etc. And she has also shown that almost 80% DSA cases are filed by those belonging to the ruling party. So this is not surprising. In a sense, this is not surprising. Because if I am a devil's advocate, then I can say that I can defend this stand of the DSA. The question is why? First of all, we have to understand that there in Bangladesh, there are huge amount of public monies are regularly spent for building the image of those in power, for building the image of the persons belonging to the ruling party. I highlight, huge amount of public monies are regularly spent for building the personal image. This is unthinkable in a mature democracy, but this is well accepted in our country. If it is well accepted, then from the state perspective, it is right to defend that image by coercive means. So unless and until we as a citizen of the country come forward to question how our public money can be spent for building the image of an individual in power, then the questioning the DSA cannot be very fruitful. So these are the aspects that Priya Aasan may consider in further developing this paper. So these are the all comments that I have. Thank you, everybody.
Thank you, sir, for your valuable feedback. I hope the presenter will incorporate this valuable feedback in advancement of their respective papers in future, because we know sir is an academic. So the feedback given by him will be really valuable for you. Now I would like to request an eminent jurist of Bangladesh, Senior Advocate, Supreme Court of Bangladesh, and also law academic, Dr. Shadin Malik sir, to give feedback on the papers. Sir.
Thank you, Rohim. Thank you. My first reaction is all the presenters were very brave. And I should sort of first start with the appreciation of their bravery, in the sense that pandemic is very new for all of us, right? We sort of 2 or 3 months into pandemic last year, we came to know that the last pandemic was literally a century ago, the Spanish flu. Then I think only towards the end of last year, it dawned on us that it is going to stay. We still don't know whether it's continued through 2021, 22 or beyond. At least in our parts of the world, it will certainly continue through 2021 and 2022. Maybe some sort of developed countries will tackle it earlier. And then obviously there are further alarming sort of thoughts and noises about other possible pandemic in the near future. The brave in that sense that the legal relation or legal connection with pandemic itself is the newest thing for us, a worldwide phenomena. And then to think about how laws relate to various aspects of pandemic. It's a bold, brave venture, because most of our legal thoughts or laws are still, I think primarily, I would say even 90% based on Enlightenment ideas of sort of 18th, 19th century. What we think about law, what we have been led to think about law, read about law, are premised on philosophical ideas of 100 years ago. And suddenly that world has drastically changed. Faced the two realities. And law, not being a science, is always very slow to react to new situations. In that sense, if someone had asked me to write something about law and pandemic, I definitely would have said, come back in 5 years. So I think this one advantage of being young is you tend to be more brave when one is young, and you tend to be less so as you grow older. So I'm really encouraged by the presentation of all your presenters. And I'm lamenting that I should have made an effort to attend some other sessions. So, and obviously I also congratulate them, because I'm sure for all of them, these are very recent, very new topics. And they have pretty well connected this new reality with the old laws, or brought in new analysis of old legal provision in light of this pandemic. Mahbub have summarized the papers, and I don't have hardly anything to disagree with them. Topic clearly, the theme of this evening's presentations been, I think, financial crime and restriction on freedom of speech in pandemic. In happier times, I had been reminded of Gabriel Garcia Marquez's sort of very popular novel of my younger days, Laughs in the Time of Cholera. So we are now sitting in all these things in the time of pandemic, Corona pandemic. That was, sorry, Marquez's book was Love in the Time of Cholera. We are getting all mixed up. So again, my appreciation, and both information, malinformation, misinformation, one hand, and the second paper on widening scope of cyber-related financial crimes because of our, I mean, again, as in the first paper, the information in this time of pandemic is playing a crucial role in both helping us to be more careful health-wise, and also doing the opposite to preventing us from taking the appropriate health measures. And it's absolute, the information campaign in this time of pandemic through cyberspace has created a really chaotic world. One frankly does not know what to believe and what not to believe. And in this chaos, law's role or roles, I would say, if any, would be really thought through and carefully. And obviously, we hardly had time. We are just waking up to the fact that law may have a role, we are not sure. So we are sort of toying with several ideas, and all your presenters have been very brave and very, they've taken on these issues heads on. Similarly, on the second paper, pointed to the fact that massive increase in cyber transactions, cyber financial transaction, bringing in unthought of problems, prospects, etc. I mean, even for us, the idea, I mean, I have been doing seminars and conferences for at least 3 decades or more, and that one could attend seminar or discussions, conferences through cyberspace is also a very new experience for all of us. Almost all over the world, and literally during last 8-9 months. And the DSA's issue is an old one for us. So again, my general comment again is totally of appreciation. Totally of appreciation. And the courage of young scholars, and I'm really encouraged that I would hesitate to path this sort of roads to link try to link pandemic with the legal regulations. It's really heartening to see that young scholars have already begun to do so. Generally, only thing I would urge is a bit of more caution, because I mean, it is the pandemic has changed our world, and it is changing our world, and unfortunately, it may continue to change our world in several ways, in several ways that some of us has got used to, and some it's totally unknown. So all we need to do is be more cautious. Information has certainly taken on a new meaning that we are not aware of just literally a year ago. There has been misinformation, and in sort of the world of political narrative has been full of misinformation, malinformation, but that was more confined to the world of politics. This in the United States of last 5 years being a very good example, and it has caught on in other parts of the world, and it has caught on into Bangladesh also through DSA. So the information, suddenly misinformation, malinformation, and what Mahbub has said, genuine information, all these have become a very new phenomenon. Just of last 2, 3, at the most 5 years. With the explosion of all other sector, media, platform, new forms of information technology. So new forms were there. www, World Wide Web is more than 30 years old. But this sudden proliferation explosion, Facebook culture is literally 5 years. And similarly, cashless transactions, cyber transactions, financial transactions, again, we're using sort of in UK in early 90s, but even ATM card in South Asia, our part of the world, is hardly 5 years. And cyber transaction is, as with many countries, it's just literally 1 year. We have begun to make a lot of our payments. And DSA is also relatively a new law, obviously, we all know. Particularly those of us in Bangladesh or working with Bangladesh law are more aware than our friends from Nepal and Poland, and has been a very controversial law in recent years. So again, I don't have any concrete suggestion except appreciation and some caution. One aspect of our law and international law, there's been some reference to international law in all the papers, but in Bangladesh, we may become a party to sign or ratify an international legal instrument. But I think our sort of conventional procedure is that it has to go through the parliament. That same international legal instrument has to be translated into a law and enacted by the parliament. We have to mention this Hafazat-e Nirjatan o Mittu Nivaron Ain. I think the preamble of that law does refer to International Convention CAT and all that, but it has become an enforceable law because it has been enacted by the parliament. Otherwise, international legal instruments, we cannot take it literally. Though I had a couple of years ago, 3 or 4 years ago, when 2017, I think, I had argued that the Refugee Convention of 1951, I had argued that Bangladesh is neither a signatory nor ratified the Refugee Convention 1951, but I had argued that irrespective of whether we are a party or signatory or ratified, whatever, this is part of customary international law. And international law, that customary part of international law, irrespective of the formal sort of adoption, is obligatory on every nation. And surprisingly, our High Court in that case accepted my argument that though we have not ratified the Refugee Convention of 1951, by dint of the fact that this is recognized as customary international law, it is enforceable in Bangladesh. Okay, it has been, overall, it has been learning experience, pleasant experience, and I thank all the presenters and Rohim and others at the university for also being bold, taking on this sort of the whole theme of law in the time of pandemics. Thank you.
Thank you, sir, for your valuable feedbacks. Really, the young are fearless. They do not care, even they do not fear anyone. What we think, we may censor ourselves, but they do not censor themselves. They are fearless, and it is a good sign for Bangladesh that we are improving day by day. Our youngsters are courageous enough to tell the truth. Thank you, sir. With us, there are also other distinguished Professor Dr. Jamila A. Chaudhary. Madam, Dr. Jamila A. Chaudhary. Madam, are you with us, madam? Madam? There may be a connection disruption. That is why we cannot listen her.
Yes, Mr. Rahim, I'm here.
Ma'am, would you like to say something about the last session today? This is the last session of our international conference. We have 5 minutes. You may please express your
Thank
opinion.
you so much for giving me the floor. In fact, it is the, perhaps it should not be claimed like that, but from day before yesterday, from 10 o'clock to today, this is perhaps I am one of the very consistent, continuous audience, as well as one of the panelists who was all the time with you. So most of you relating to UAP, I believe you know this is the time that is in fact 6:30 is the time which is an obstacle time for me, that I generally have to attend to my mother who is in hospital. So all the time previously with Nazia, day before yesterday, tomorrow perhaps the moderator was some I cannot exactly recall who was there as moderator yesterday. Today you, all the time I made just a message that at 6:30 at best I can be with you at 6:45. So all together, since I'm there as a closing ceremony today, otherwise I had to leave prior to 6:30 in general in last 2 days. As I said earlier, today it's to our youngsters all the time. I appreciate what UP as well as in partnership with UNESCO Madanzit South Asian Studies, what you have done is an excellent work. It is not perhaps, it's certainly the first. UP is the pioneer in this field during this COVID-19 period for organizing this two stream, both national and international together. So in our Dhaka, we Dhaka University Forum has also organized previously both national and international forum. However, it is not during the COVID. That's why I highly appreciate that during the COVID, UP has organized these kinds of a big platform combining both national and international scholars. Most amongst those, most of the youngsters who really show their courage, interest, which I really appreciate much. It will, at this particular point, perhaps it would not be exaggeration if I say that, and perhaps you will be happy to know that when I was requested by UP to accumulate or at least invite some of the students so that they can attach themselves with these particular forum. I have tried my best from the first year, second year, third year, fourth year, and up to fifth year to accumulate them as much as possible. And what is the most unique thing which I impressed much, that is the first year student, even the elementary student at the law school of Dhaka University, that means the first year, they have appeared this international conference. That is the most unique point, that how much inspire our students if we really give them the flow, really give them the opportunity, how much they are really eager to engage themselves with these kinds of fora. So I hope UP, the pioneer, I will not say as one of the pioneers, because is the only pioneer during this pandemic, that it will ultimately continue this effort. We don't know how long the pandemic will continue. Nonetheless, if it is not like that, in another style, you should continue this for these youngsters in future. All the very best for you, and congratulations to all young, brave fighters for our future. Thank you so much.
Thank you, madam. Thank you. Now, it is the time for presenter. After taking feedback from our panelists, if you have to say something about your presentation or give thanks to the panelists in general. Presenter, please. Nikhil?
Thank you very much, sir. So it was very honor. I really enjoyed the session, and I feel very thankful for the opportunity to participate in the competition. So even though there was the presentation was good, there was some technical mistakes. I believe it's a technical. So let me not remind you the mistakes. So yeah, if the organizer wants, I will be happy to provide you the slides. So it was a wonderful experience learning. Yes, it was very good. We would obviously incorporate those comments in our articles. That it's a very serious issue that you have raised, and we'll definitely put that articles. So thank you very much.
Dr. Nijol?
Yes, I also thank you for all the comments. I think I will improve my paper, and it will be better and more up to date and more research, more interesting in the field of research. Thank you very much.
Thank you, Nijal, and most welcome to our University of Asia Pacific. If you ever visit Bangladesh, you are invited to our university.
Thank you very much. I also invite you to the Szczecin University in Poland. If you will be in Europe, Szczecin is a city close to Berlin. So if you will be in Berlin, so I also invite you to Szczecin or in any other case. Thank you very much.
Priya, Aasan, please.
Thank you very much for the opportunity, and thank you also for the comments to the panelists. I'll try to, improve my paper based on those comments. Thank you very much.
Okay, thank you. Now we have got another distinguished professor with us, our familiar teacher, Professor Kazi Mahfuzul Haq Shupon, sir. Sir, would you like to say something, sir?
Oh, thank you. It's just a side note, specifically to Christina. You have put much emphasis on cyber law for mitigating cyber risk to financial transactions. That was very fascinating and interesting to me, at least. The basic problems and issues that are inherent in cyberspace, for example, no single entity controls it, and information is not located in a single place, and it's not connected to any specific territorial geographical jurisdiction. And most of our all forms of mango crimes, as they call it, the financial crimes, they are most likely to be committed from foreign territories. So I think, to add to your argument, cyber law may not and will not help always. Since the only treaty, the Budapest Convention, is hardly ratified or acceded to by countries outside Europe, and there are safe havens, for example, Russia, China, and North Korea. So my proposal is you could include in your paper the cyber diplomacy may have more impact than cyber law. Thank you.
Thank you, sir. For your kind information, today is the last of our 3 days international conference. At 7:30 p.m. there will be a closing ceremony where the eminent jurist professor will join. So let me request all of you to join there. And now the question answering session. If the participant have any question to the presenter, you may ask, or if you have any feedback in general, you may give within shortest possible time. Please, if you have any question.
I'd like to ask Dr. Christina regarding to the European Union law, especially on cybersecurity. Do you think it's like this is sufficient or better than the Polish law, or the role of the European Union law regarding to the cybersecurity problems during the COVID-19? I would like to hear your comments on that. Thank you.
Please, could you repeat the beginning of the sentence, because it was some disruption and I didn't hear that.
So does the European Union took any initiative to sort out the problem that you are facing in Poland or Polish law to sort out the during the COVID-19 crisis, particularly on cybersecurity? Thank you.
I think that the problem of cybersecurity was before the pandemic, because the Cybersecurity Act and the cyber construction of cybersecurity in the whole European Union was before the pandemic. Maybe some of the changes or the pandemic just shows that some of the problems can be regulated in more specific way. But in I would say that the main construction was before the pandemic. So what can be a challenge? There are intensification of new cyber threats, and because as it was mentioned before, the pandemic, it's completely new situation. So I also that the European Union regulator has to face new problems. But the main construction was before the pandemic of the regulation, like the Cybersecurity Act. In Poland, it was also like this recommendation of financial authority or the cybersecurity strategy of Poland. It was maybe several years ago. So the main, I would say, the fundamental regulations are, but maybe they will be changed before of the challenges of the new situation connected with pandemic.
Thank you.
Thank you.
Thank you very much. There will be Maghrib prayer now. So we are at the end of the session and also end of the conference, except the closing ceremony, which will be held at 7:30 p.m. We know even after the departure of the coronavirus or the COVID-19, the world will not be the before life. There will be new normal world, as has been said by the expert. So we have to adapt with the new normal world. And with the low academics, low student, low teacher, low professional judges, we have to be prepared ourselves to adapt with the new situation, new world, new normal world. Thank you very much for being with us, and thank you again. I'm inviting you to join the closing ceremony. Please, thank you. Thank you all.
Recording stopped.
Bhai,
Yeah, madam.
same link na? Same link na?
না না আরেকটা লিংকে আছে
সেম লিংক
তাহলে তো আর ইয়ে হওয়ার দরকার নেই, কানেক্ট হয়ে থাকে।
মাহবুব সাহেব